We're now going to move on to our ethics presentation that I am going to do. And anybody feel free to unmute yourself and ask a question. The more interactive ethics presentations are, I think the better they are. And or you can also feel free to ask it in the chat. I'm watching the chat as well. All right. Hope everybody can see my screen. We're going to do this one with a little PowerPoint because we cite a lot of rules here. This PowerPoint is also in a PDF format on our website. Remember that whenever we're practicing with the backdrop of our ethics rules. In this presentation, we cite both Missouri and Illinois. Ethics and litigation, the hard stuff. I tried to pick out some of the harder stuff, and some of these questions you kind of know the answers to, but I think that knowing why and getting the detail of this is good and a reminder for everyone as well. First question, can you not pay liens for your client? This is an interesting one to me. So a lawyer cannot guarantee payments of liens in a settlement. My watch is trying to tell me that she can't hear me. So I'm going to take my watch and move that over there. I was moving my hand. So can you not pay liens for your client? So remember that in a settlement agreement, the lawyer cannot guarantee that you, in Missouri, that you cannot, in Illinois, we cite the two advisory opinions in here, you cannot guarantee payment of a lien. So I don't really get it that much anymore, but if you got to watch those releases. If they're asking a lawyer, I try not to sign releases. Sometimes they want me to sign them, but let's look what you're doing when you're signing them. And even if your client just signing them, you can't have a phrase in there that says the lawyer can guarantee to pay the liens. The lawyer can and the client can to protect and indemnify the insurance company if the liens are not paid, but you can't guarantee payment of a lien because technically you can get the money, your client can direct you. I know you have that lien, or I know the lien goes to the insurance provider, don't pay that lien. They can do that. Remember, ERISA liens really aren't liens to the insurance company. They're really subrogation interests into the recovery. So if the client technically wanted to dissipate that, they're going to invite more litigation, but I think technically they can. Now, here's something that I wasn't aware of until a few years ago. There's this interesting rule in Illinois that I have not found in Missouri that seems to go the other way. What it says is that under Rule 1.15b, a lawyer representing the plaintiff has an obligation to segregate the settlement funds for liens, to notify them, and then has to distribute the money to the lien holders. So there's a tension here to me that this is requiring the lawyer in Illinois to pay liens. Now, that is an interesting thing, and I have not found cases on it. I have looked, because remember the Illinois lien reduction statute is not as powerful as Missouri's. In Illinois, you can use the lien reduction statute. It's separate. And incidentally, if anybody wants to email us we have great Excel spreadsheets that are the lien calculators for pro rata interest for the different providers in both Illinois and Missouri, because the law is different. Illinois has like 40% of the hospitals, 40% of the doctors, 20% to someone else. I forget it. But in Illinois, after the lien reduction statute, the people are not discharged. So even if you use the lien reduction statute in Illinois, the provider can still go sue the client for that. So which is why in Illinois, you want to make sure that you reduce the liens to zero, so that the lien holders accept everything. In Illinois, you can't just use the lien reduction statute, send them a check and say, see ya. You got to watch out for that in your client. So this is it. So you can't, so in Illinois, you cannot pay lien, you cannot not pay liens for your client to make that more confusing. In Missouri, I think you can not pay liens for your client, but there are these obligations. And if you were presented with that issue, you can get an advisory opinion from the Illinois or Missouri ethics folks. You can call them up. You can say, listen, I'm in a rock and a hard place, but which I've never had this problem, because I've always had a discussion with my client and say, listen, you don't want to do this because you don't want this bill chasing you around. This is the best opportunity for you to resolve this lien and reduce it, because it's just smart to do. You don't want this chasing around. And Darren, thank you, Darren. Darren Sorrell of Sorrell and Traube has he cites 1.15D about promptly notifying the client or the third party. But he said, but anyway, I think it is different because it doesn't have that last clause, and it says, and then distribute the funds owed to said persons. So it's just, if you're faced with this issue, if you're put in this box, the lawyer, you don't want, the lawyer doesn't want to be in this box. You want to avoid having to be in this box at all. See, this says 1.15D in Missouri says, then you shall promptly deliver to the client or the third person any funds or property that the client or third person is entitled to. So we always think that these are rules are the same between Illinois and Missouri, especially ethics rules, because they're model rules. They're not. So keep an eye for that. And if you're, and before you do it, get clearance from the ethics folks and put the onus on your client. Maybe set, one of my tricks for resolving liens, which is a separate CLE, is sometimes I leave this money in my trust account, which is another way to get rid of it, because you leave the money in the trust account, you give the client the rest of the money, you tell the lien holder, listen, I can't agree with you. You want too much money, your air flight bill or whatever it is. I'm going to leave this money. You let it sit there, and then you tell your client, whatever I save you, I'm going to send you down the road. You sit there, and then you wouldn't believe the lien holder calls you back 3 months later, says, and say, I still have that money. They'll take the deal later on. They're losing money. They'll take less, and then you give your client that. So just something to be cognizant about. Next question. Can you represent the driver and a passenger in a car crash? This is the classic case, right, of conflicts. Well, it's not a yes or no answer. The answer is it depends. If there is no allegation of fault on the driver, for instance, a rear end crash, I think you can. But if there is, then no. Because if client and passenger are sitting there and they're rear-ended, or two passengers, and there is no allegation of fault, then I think you can take those two cases. You want to have a upfront conversation with the clients and explain to them the circumstance, and explain to them what's going on, and explain that if they don't have an identity of interest, then you're going to have to refer the good case to Berger law. Don't take the bad, but remember too, that just because there is no conflict in the beginning when you first see the police report or you're talking to everybody, that doesn't mean a conflict isn't created later on when you file suit, when you hear the story of the defendant, when something else happens. So even if you feel there is no conflict at the beginning, to make sure your clients understand there could be one later. There may be a time when you can't do it later, and they understand that down the road. And then have a friend. We all have friends in this business. We all know each other. Have a friend who will take that conflict from you, take the conflict case for you, and vice versa. Have these relationships. But, and we have rule 1.7 about concurrent conflicts of interest if representing one client is materially adverse to the other client. Because you got to remember that if you have the driver and passenger, and then the defendant starts, and it can be a bogus story. You can say this defendant is lying, but it doesn't matter. If the defendant starts blaming the driver, then the passenger has a claim against the driver. And then if the defendant who rear-ended the car or whatever, if they're paying 80 cents on the dollar, or or 50 cents on the dollar because they say the driver's at fault. You have to make a claim for your passenger to get them whole recovery. And then remember too that these can be waivable conflicts. So even if you have a conflict, if there is potential, get a written waiver. Each client, not just the driver, but the driver and the passenger, each give informed consent and informed waiver, have them sign it, keep on going. But if there ends up being an assertion of one claim by the client against the other, you can't do it. It is not a waivable client. It's not a waivable conflict, excuse me. Remember that you don't even want to get close to this line. If you're even close to this line and doing this, you're already in dangerous territory, and it is not worth that extra interest in that fee to keep this case going, to get an ethics complaint later, and to have the ethics committee going, what are you doing? You knew this the whole time. You can't do it. You don't want to do that. And we quote this good quote from this Horn case: representation of clients whose interests are adverse to each other, meaning they have claims against each other, is the most egregious conflict of interest. It is not worth it. Refer the case, get a good relationship. 2 years later, that person will refer another case to you. We also quote all of the conflicts rule 7 or the key points here. And I think, and you know, the other point corollary to this is you got to remember, if you're going after one policy for multiple people, you have to be really careful about making an aggregate settlement of the claims in multiple cases. So if someone's going to tender the 50 grand you or whatever, the 100, and for you to split it up, you got to be careful because those are competing interests on the rights of that, and you need to get informed consent in writing signed by the client. It's not just a conflict waiver is not just you sending a letter to CYA. It is real informed consent. It goes with a oral communication and a telephone conversation, and you get the client to sign that they're agreeing to do that. And it can happen. You know, we have cases where, look, I say this to clients all the time. They're like, oh, this is happening. We have these conflicts. I'm like, yeah, but in a car crash, people don't ride in cars with people they don't know. So there's always this, I mean, unless it's like an Uber or taxi, but this happens, and we all get it in our practices is, well, I don't want to sue mom or dad or my best friend or my roommate. I get it. But here's the deal. And you lay it out for them and you write it. And then the better practice is to move that client away, probably, because even if they don't want to sue that person later, 6 months from now, when they're really hurting and they find the limits of the driver, that the first driver is only 25 grand and their buddy who was driving the car has great insurance, well, maybe it'll change. And if I was driving a car and I was negligent, even though someone else was a lot more negligent, I would want the people in my car to recover from my insurance policy. Next question. Can I loan my client money? No, you can't. You can't. You can never, ever, unless you're in Arkansas, at least the last time I checked, but you can never provide financial assistance to your client in connection with a pending or contemplated litigation. You cannot loan your clients money. Don't do it. Don't come close to doing it. There are many loan companies out there, but also tell your clients not to use those loan companies. We have these questions. I used to have these questions more. I don't get them as much anymore. I don't know if the marketing slowed down to them. I mean, we still get them, but the other thing is I have one loan company that I kind of have a relationship with, and I call them up and I say, give my people the better rates. And then if we need to reduce the interest, we do it later on them, and they're more open to me. I tell them they're my only person I do it with. But I also, before my clients ever do that, I have long discussions with my client saying, don't do it. You're going to pay huge amounts in interest. It's not worth it. find the money other places. And then you also have a conversation with your client that says, listen, you've had an economic hit. You have life interrupted. You are going to have to make financial decisions because there's a tension between good money and time. It's hard to get great settlements really quickly. I mean, usually you have to fight and blah, 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 blah. So you're not going to get compensated for this for a year and a half unless you want to take a bad settlement. So you're going to have to, maybe you need to get rid of that truck you just bought. Maybe you need to move to a different apartment. You're going to have, maybe your wage loss. You need to accommodate your financial distress now and stop maybe control your expenditures and and deal with this, because if you want a good settlement, I'm not going to be able to get it down the road. And it may be that you have 200 grand worth of damages and there's only $25,000 worth of insurance. So you're never going to get fully compensated. That's going to be a challenge in your case. You can advance the costs and expenses of litigation, including medical evaluation, that kind of stuff. You can get medical assistance for your client on a lien basis and have the medical provider assert a lien in the case. Can you sign your client's name to a settlement check and deposit in your trust account? Very interesting. Yes. Short answer, I think, is yes. Although when we were doing this research, we found some issues in Illinois about having a signature notarized in this. So what you're doing, if you do this, is you're getting a limited power of attorney in writing from your client to execute a negotiable instrument and deposit into your trust account. Especially during COVID, I have this provision in my representation agreement where I say this. When they sign up with me, I tell them this, is that you're going to let me get this check and put it in my trust account. And so that works. It's a limited power of attorney. It's not a power of attorney to settle the case. It's only for that purpose. Now, Illinois has this statute that says, and I've read it, I thought that I was reading it saying, I can't believe this applies to this, but I think it may. There's the statute, read it yourself, make your own decision on whether or not you're going to get it notarized. Under that same rule 1.15 that we were quoting from before, you need to advise your client the case is settled, you're putting the settlement funds in your trust account, and you will distribute them. So now here's the thing you want to be careful about too is, there you go, it's the next point. So you can do it. You want your client to know it. You don't want your client to complain at you later and say, hey, you didn't tell me you were doing all this. You tell them, listen, here's what we're doing. We're moving this quicker. We're moving this quicker because no client wants to have to come in and sign it. We used to have them sign it back in the day, but we don't do that anymore, especially with COVID. Now, can you deposit the settlement check into your trust account before your client signs the release? I don't really have a clear answer on this one. The better practice is to have the release signed. There is no rush. Get that release signed before you put the check in. If sometimes they'll send a check and a release at the same time, especially if it's like lawyers that know you and trust you and know that you're not going to, play games with that. And so that you're going to send the release to your client and then you're going to deposit the check. Well, one of the ways to handle this is with technology. Get DocuSign, get another sign-in, or now you can sign on PDFs very well on Adobe or whatever you're doing. Get them to sign that release and get it back to you. Tell them you're holding the check. You don't want to deposit it yet. You don't want the client to get cold feet. You don't want the client to see the release and see a confidentiality clause and say, I didn't agree to this. Or you don't want them to be mad that they're only getting a low settlement at 25. Even if you told them that first you're going to get 25 and then you're going to have a UIM claim and then you're going to go after that 100, they're what am I doing? Blah, blah, blah. You don't want to be stuck in the box of having this amount of money sitting in your trust account and then having an unsigned release or a client that's moving on you. So communicate about it. Remember accord and satisfaction. Remember that you signing that release, you signing that check and putting in your trust account is going to obligate you to that settlement. So you got to be really careful, especially if you are, if you're not the only one who is, if you're not the only one who is working in your law firm. I mean, I have, a bunch of good lawyers working with me, and I can't watch everything. So you want to create clear policies on that. I don't want to have one of my paralegals or other lawyers working with me that wasn't clear with a client, or the client didn't think they were clear, even though we were, and getting into that game and getting into that situation. And we talk about some of these extra ethics rules, 1.15E. Remember, when this money is in your trust account, it is the client's money. Remember that you want to make sure there's a clear offer and acceptance, and you don't want to, and remember, sometimes the terms of the acceptance in the release is different than what the client thought, on confidentiality or doing liens. You don't want, what if the client, you get the money, you put in your trust account, you send the release, and then you get the child support lien, and the client says, I'm not going to do that. Well, I'm not going to make any money, or I didn't know the comp lien was this high, and they're back and they're changing on you. You want to do all this in the front end. You want to communicate. The most complained of ethics violations, when people complain to the ethics panel, and I sit on one of the regional disciplinary committees, is communication and diligence. And it's communications. Remember to communicate, put it in writing, not just CYA writing, but your client really gets it. There are bad stories out there. We cite a couple of them about accepting settlements when you didn't have consent to. Remember, don't get put in a box of accepting a settlement and a motion to enforce settlement where the client changes on you. And then if you had deposited that check, it's even harder for you to get around that settlement. Remember to be really careful and clear with the client and the other side about the terms of the settlement. Are you doing confidentiality? What are you guaranteeing on payment of liens? Are you protecting and indemnifying? Make sure the client knows you're going to sign a release, then you're going to be forever done with this. Look at the release. Make sure you're not signing, if it's a specific release, make sure you're not signing a general release. Make sure that you didn't deposit the check and the other side wants a general release, but you have other claims against this. You may be settling part of the case. You're not settling all the case. What if they're trying to take money back on a subrogation, and the amount of the consideration looks big in the front end, but if you read the release, the net amount is not that great? What if they're trying to pay the medical providers and they don't trust you? They're going to pay them separately and pay the full amount. What if they're trying to take back that 10 grand they paid in MedPay? There you go. I think I said that. What about, asked this question by Laura, what about paying for your clients' meals when you meet with them that do not include on their list of expenses, more of a gift? Would that be problematic with respect to loans? The answer is no. You can give your client a gift. You can give it, but you have to be crystal clear that you are never taking that back whatsoever. And I have had this before, where I have had clients who have financial problems and sad stories. And I have before, I've just sent them, here's $100. And I don't do it very often. It's really a special thing. Or, what we do is we, in death cases, we're always contributing to the fund whatever the fund is for the poor deceased person. Or, but I have had rare instances where I said, listen, but I'm clear with the client. I call them, I say, this is a gift to you. It's not going to be hidden in my expenses. I'm not secretly getting this back. My heart breaks for what you went through, and I'm giving you this too. But don't do it for rent, and don't make it a repeat thing. I've never been bitten by this, and I've never had a problem with this. And it's been very, very small amounts of money. Here's what you don't want to have happen. So I used to work for a great lawyer named Bill Brasher, And Bill Brasher was crossing I tried a case with him one time, and he was crossing a railroad. We were on the defense, and he was crossing a railroad employee. And he said, Bill said to him, he said, you haven't worked for 4 years or something like this. You have a boat, you have a house, you have all this. Do you have payments on those? Yeah, I do. He said, how are you paying for all this? And he without missing a beat, the client on the stand in trial in the city of St. Louis has said, my lawyer's paying me $1,000 a month. Shocking. And Bill got a defense verdict in that case. But don't get close to that. So you can do meals, you can do little things. You can contribute. There you go. I think I said it. What do you do? Sorry, here's my next question. When do you report another lawyer to the OCDC? Now, this is a tough question. We see things as lawyers, especially in in a litigation practice that is by nature adversarial. You see things that, or you get a case from another lawyer, or you have multiple people. I don't know. You see ethics violations. You can't. It happens. It's happened to me. It's probably happened to most of the people looking at this. So when do you report another lawyer to the OCDC? So we look to the rules to answer these questions. You should. All right. So Rule 8.3 requires mandatory reporting if, quote, a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So substantial. The word substantial in that comment refers to the seriousness of the offense, not the amount of the evidence. Knows can be inferred by the circumstances, more than mere suspicion, but less than absolute certainty. That's fine. This applies to judges too. So to answer this question, if something happens, you see something, you need to sit back and say, because it is our job to protect our profession. It is our job to protect the reputation of lawyers that is attacked all the time. And we're a self-regulating group. And if you're not going to, so you have to be able and willing to go report someone. This doesn't mean, to me, it does not mean you're a bad guy, but you need to think, do you want that lawyer going out and trying to call represented people in violation of 4.2 and 4.3 to try to steal cases? Do you want that lawyer to take money from a trust account? I think we know the answer to those questions. Those would be reportable, and especially trust account violations. But what about the misrepresentations that you see where they tell you? Or what about diligence? Those are harder questions. You get a client calling you, so-and-so had my case for 4 years, didn't do anything. Are you in suit? No. Is there a demand letter been sent? No. Do you know you have a year on your statute? No. Well, what do you do? I don't know if that violates diligence. Sure. Does it violate competence? Maybe. Does it violate communication? Maybe. Is that something that you want to report to the OCDC? I don't know. Do you want to tell your client that they can do that? Maybe. It kind of depends on how that lawyer relates to you and interacts with you. If they say, go to heck, we're not talking to you, we did a great job, and we're going to assert a lien for all this money. I know the client fired us, and I know it's a $25,000 case, but we want the full third. And you're like, what? So there you go. Hopefully, it's not close calls. And then you need to, in the way I think it, you need to think about how is that conduct going to impact other clients in the future and the reputation of the law firm. Is what that person's doing, is that conduct indicates something else going on with that lawyer, like an addiction problem, like a drinking problem and stuff, which sometimes go hand in hand with things like, the OCDC people, I've heard them say that if someone's taking money out of a trust account, it's a high percentage of time that the lawyer also has an addiction problem or is not making those decisions. Sometimes lawyers don't understand the ethics rules. They kind of mail it in listening to me talk and things like this. Not that all of you aren't like on the edge of your seat in the middle of an ethics presentation. I get it, but you need to know the rules on trust accounts. You need to make your hardest phone calls first. If you have a stale file sitting in your office you haven't looked at for a year, go look at that file today. Make your hardest call first. Work on your oldest file first. It makes the rest of the day easier. All right, I think I've said enough about that. Can you ask for Facebook Avo, super lawyers, or Google likes or reviews and give something of value? The answer is no. It's very interesting how the ethics rules are a little bit behind what marketing and what the reality of social media is today. Do not give something of value in exchange for likes or reviews. That can be considered a violation of Rule 7.1H as paid testimonial or endorsement without the conspicuous identification of the fact that the payment has been made for the testimonial or and I think there's a subpart C. Oh, there it is. It's the next line. Thank you. You can't give something of value in return for a recommendation. And this goes back to you can't pay people to get your cases. And you can't hire runners. That used to be in the railroad world, the railroad plaintiffs world. You can't hire runners. You can't hire people to go get cases for you. That violates 7.C. Well, can you go pay someone to give you a Google review? No. Can you do that? No. Now, can you offer? Now, here's the distinction. I think that you can pay people. You can do a thing where, hey, everybody who likes I do this, and everybody who likes my Burger Law Facebook page, I'm going to put you in a drawing in 30 days, and then you're going to get tickets to Cardinal games. We're going to have a promotion. Those used to be bigger than they are now. I think that's okay. You're not asking anybody to give you a review. You're not asking anybody to recommend you. Liking a page is really subscribing to a page. It's not endorsing necessarily, but I don't even want to get close to that rule. So if there's a different social media site that isn't like that, then you can't do it. You need to be conscious of this. Now, the funny thing is about this, if you get into all the details in these rules and all the comments, there's a million exceptions to this, and the exceptions almost swallow the rule. You can pay for a referral group, and I get about 100 of these a day. We're going to send you 20 cases a day, and they're all going to be $1 million cases, and pay us whatever. You can do that. You can pay for referral groups. You can pay to be like a recommended person in a union. You can pay them for that. You can pay for business development and staff and web designers and social media consultants. You can pay people to market for you, but you can't pay people to solicit for you. You can't pay people to go around the ethics rules for you, whether that's Rule 4.2, communicating with people, whether that's rules on advertising. You can pay people to generate leads. You can pay the usual charges. Here it is, the usual charges for a legal service plan or loyal referral service. So there'll be people that used to be, we as a member of a union or another group or veterans groups, as part of our membership, you're going to get a free lawyer consultation, and lawyers pay to be in that so that they get those client funds, and they get a lot of calls, and they take care of traffic tickets or divorces or this or that. So those are okay. And lawyers can refer cases to each other. We can refer cases to each other and pay a reasonable value of that, as long as we're co-counsel or jointly responsible for that file. A lawyer may refer cases to another professional lawyer with the promise that the other professional lawyer in return refer clients to that lawyer. Can you have a secret deal with a chiropractor? where the chiropractor sends you business and you send him business. I think you got to be careful with that. Remember the second injury fund problems that got people into trouble 20 plus years ago now. Remember, there was just one, you guys will remember the story. There was someone just got in trouble for this. There was just a bunch of indictments with a bunch of scam going on in the city with a chiropractor and some people. And I'm sorry, I forget the details. Be careful of this. Be careful of it. If you're getting close to the line, don't do it. Only do stuff that's straight on the up and up that you'd want to tell your mother about. And in fact, I think my mother is on this CLE, so I can tell my mom all the stuff I do. All good. Hi, Mom. All right, client. I got about 15 minutes left. I'm going to keep going through this stuff. Oh, here you go. Client assisted advertising. Here's something I do in my contracts. Nothing in rules 7.1 or 7.2 prohibit the use of client information for marketing, so long as the restrictions enumerated in the rules, blah, blah, blah. So I put something in my contract at the beginning that says, we allow Burger Law to publicly disclose some parts of the client's case in connection with Burger Law LLC's marketing efforts. And I try to do that. I try to tell stories of my clients because I find that I tell this to my clients when I do these videos. I say, the things that you learned in this case are questions that everybody else has. So it's going to teach people stuff. And I think everybody should get this information so that our clients are savvy consumers of judicial service, of lawyer services, as well as being able to combat these insurance companies or these claim reps that are calling them, trying to get them to sell cases quick on the cheap, and they need to know their rights. So we talk about that now. But if a client ever tells me, I don't want you to talk about my case, I don't talk about it. Some of them do. We don't use it. You want to do? Can we talk about it? No, I'm shy. I don't want to do that. I'm not so great. We don't do it. So just because you put this in a contract doesn't mean you got them. You still have a conversation up front with your client about what you're going to talk about in their case, because money may be private. Their injuries are private. Just because they sign this doesn't mean you're good. You need to still request permission prior to using, be very specific, and don't reveal confidential information as part of the disclosure. So I have a question from, hey, Tom, thank you for the good question. Let me go back up to these. Gary, should you ever sign a agreement from injury case lender the client wants to borrow money from and signs an agreement with them or not? If the client decides at the time of settlement order for you not to withhold the money, if the client decides at the time of the settlement to order you not to withhold money for the injury case lender, you cannot do so. So if the client insists on having you sign the agreement, should you put a withdrawal on the case? It puts attorneys in a terrible ethical position. Yes, it does. I think that what we do is we sign an acknowledgement of the loan in the case. The client knows it. We make sure that we have 5 emails telling the client not to do it before. But sometimes it's hard to tell a client on a loan if they're going to lose their car or their house and they have kids, and how can you tell a client? I mean, you tell them, don't get the loan. You're going to pay twice as much back in a year or 2 years. It's terrible. But how do you tell them in winter that they should be kicked out of their house? That's a tough position. At the end, though, I've never been put in the position, Tom, of not paying back a loan. What I do is going into it, we always gather all the liens. So the clients, you can tell a client what they're going to get in the first instance from the defendant. What the client wants to know is what they're getting in their pocket. So you always want to move that conversation of what they're getting in their pocket. And then you got to bring that lien into that. You got to bring that lien, and if not, they're going to get sued. And you just don't let that. You try not to be ordered not to do it. You try not to be put in that position. And then what you do is you call the lender and you say, listen, this case is settling. This case went south. Liability changed. I know you did this loan before, but you guys are advertising this person on TV. You got to reduce it, cut off the interest. You try to avoid being put in that position, Tom, by being an advocate for the client against the loan company to try to get them to lower the amount to make the case be able to be settled and be resolved, just like you do with any other lien holder. I think that's the best answer that I have. Can you call Next question. Can you call the opposing party in a case? Rule 4.2. Rule 4.2 used to be more litigated than it is now. So the answer is no. So you cannot, if a person is represented, you cannot contact or communicate with that person about the subject matter of the representation with the person. You can't have your client do it around you. That's still a 4.2 violation because your client is an agent of the defendant and you're tempted to do it because your client knows the defendant because they were in the same car together, or he works for him, or they're buddies, and or they went to their house and slipped and fell on the ice or got bit by the dog. Hey, can I call my guy and get him to admit all this shit, all this stuff? No, you don't want to do that when they're represented. So if you have a case where you want to go take a statement of the dog owner or the property owner or the driver of a car, do it before you file the lawsuit because they're not represented. Do they have insurance? Yes. Does that mean they're represented? No, it does not. So if you want to nail down liability, you do that. Now you got to be careful a little bit because the person isn't insured and the insured has a duty to cooperate with the insurance company. So you got to be careful. You don't want to kill coverage by being too cute by half, as the English say, right? But don't violate 4.2 because you can get sanctioned and it can hurt you. Remember that now it applies even if the represented person calls you. You got to terminate the communication. It can be tricky where you're dealing with an organization, though, and it's prohibited communication if you know. So if you recall witnesses or the defendant or something, don't do it in litigation. Get it done before. Don't get close to that 4.2. You can't hide your head in the sand. Oh, I didn't know they were represented. Oh, really? It's not actual knowledge. The standard is not actual knowledge. It's inferred by the circumstances. If you file a lawsuit and you think that you're going to you're like, oh, I forgot to take a statement. Did you take a statement? No, I forgot. Okay, we're going to go take statements real quick before the other lawyer answers. No, probably not, because it's likely that person has a lawyer, even though there's not been an official answer filed yet. Now, remember that if you're dealing with an organization, you still cannot do this. 4.2 prohibits communications with a constituent of the organization under 3 circumstances. You can't talk to a person in an organization. It's a managerial person, someone who supervises, directs, regularly consults with the organization's lawyer concerning that, or a person who you can get liability against. So or a person with respect or in the organization respect to the matter, or whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. That's who you want to talk to. You can't do that. So managerial and someone who, and then a co-employee negligence, even if they don't have managerial authority, if they were the person negligent, you can't go take their statement if they're represented by someone. If you're pre-suit and you call someone and you're going to take a statement, you want to ask, are you represented, and find it if they are. If they say, well, I know we didn't enter, I know you're not in lawsuit, but I do have a lawyer, and I gave a statement the other day. If you know the company investigated, the lawyer came and investigated this bad incident, then you can't do it. It's not worth the admission you're going to get in the statement isn't worth doing it. Remember, though, that former employees are fair game. There used to be a disconnect between the federal courts and the state courts. Remember, if someone's a former employee, you can call them and get a statement. Remember, if it's a former employee and you call them and they say, I know I quit, but I'm still represented, then you can't. If you're taking a statement, get on the record in the statement, ask them that they're not represented. At the end of the statement, blah, 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 blah. Hey, just want to make sure you're not represented by any lawyer, or you know I'm not. Okay, great. Thank you. All right, I'm going to fly through. I have about 5 minutes left. Can you call the person who you saw? So I'm going to try to give yeses and nos. Can you call the person who you saw in the news who just got in a wreck and get them to be your client? No. Don't solicit people. Don't be don't go like in the beginning of the movie The Verdict, where Paul Newman goes and hands out his card at a wake. You can't do in-person solicitation with someone who you know just got in a wreck or needs this. What can you do? 7.3b governs written solicitations and tell you how you can do it. If you want to know it, if you want to start writing people who got in car wrecks or whatever your business is and or got DUIs or traffic things, you can do it. You got to do it like this. You got to keep it. You got to write advertisement. You have to do, it has to be exactly like this, and you have to keep it for like 2 years. I don't do this, but I think it is, you got to keep it for 2 years. Illinois is a little bit different. We put that in the end. You have to say advertising material on the outside of the envelope. Look at the rule before you do it. Keep it in case you get a complaint later. 7.3c contains additional rules for written solicitations in Missouri. Abide by that. Look at the rule. Okay. And Illinois, Illinois has this advisory opinion, 92-17. Again, it's more limited to prohibits. Illinois is more limited to prohibit solicitations only when the target is made known as desired not to be solicited. So the rules are different. Look at those look at those rules if you're engaged in that. Should you? Thanks. Hey, Steve Gerring put this. Steve, thank you. That's right. Mitch Davis was getting police officers to do that. Don't send your clients to Mitch Davis. Should you sue a client for fees? No. Unless you materially advance the case and secure a good offer, then you may want to sort of lean. Look, you got to be tricky about this. If a client fires you the day before a mediation, you should and hire someone else, you should get all those fees. If a case is settled, that kind of thing. If a lawyer is trying to take cases from you and that happens, then you have a right to the value that you gave in the case. And it's not just your hourly fee. It's how much did you materially advance the case. If you got the expert, took the statements, sealed it up, talked to the defense lawyer and all but had the offer, you should get all that fee. You shouldn't have that happening. And lawyers should not be taking clients for fees. That's against the ethics rules because you're putting your financial interests over the interests of the client. So avoid that. And I have these recommendations generally about what to do. Remember that a fee dispute with a lawyer is different than a fee dispute with a client. The way I postured these questions are this is, should you sue a client for fees? And if you fire a client, and then the rule on fees. So look at the rules. If you're going to go sue a client for fees, you're going to invite an ethics complaint. Then you got to look at why aren't they, have a conversation. Why aren't you firing me? Remember that the ethics rules that in a fee dispute with a client, the lawyer should consciously consider a fee dispute resolution committee. Go to arbitration, go to a fee dispute resolution committee. They'll take care of you. If it's with a lawyer, you can litigate the fee dispute in the case. You can file a motion for your attorney's fees. You can litigate that in the case. You can file that. You can have an agreement with the lawyer to litigate it and resolve it in arbitration. You can litigate that fee and go on appeal if you want. And there are in-rate couples. There's a bunch of cases where this has been ruled on by the Court of Appeals and the Supreme Court about the rules on value of fees with terminated clients. So there you go. I see that I am at the 150 mark. I'm just going to tell you the topics and tell you to go look at the material. Don't keep your IOLTA account sacrosanct. Don't ever take any money from your IOLTA account. Remember, the OCDC can audit your trust account. Remember that if you ever get a bounce check in your trust account, it automatically red flags to the OCDC because they know something's going on. What do you do if you get an ethics charge? Read that. Call me, I'll help you. There are lawyers that handle it too. Mike Downey's great. Explain the matter. I handle it. You can handle it yourself. You don't need counsel. If you're comfortable with it, respond to the ethics complaint, point out what you did. If you need ethics counsel, get them. I have some ideas about what to do if you get an ethics charge. Evaluate what you did. Don't make your ethics problem worse by being anything less than completely honest and transparent with the OCDC. If you made a mistake, own it. If you didn't, own it. If it's in between, say what it is and say, yeah, I was a little bit not diligent and maybe a little bit bad communication, but here's what I did. I did my best. Here was the problem. Keep these in mind when you practice, because you don't want to be in this position if you can. Two most reported rules are diligence and communication. Folks, if you ever need help, we have a stressful profession. We can have stressful lives. Look at the end of my presentation about getting help. MOLAP is always confidential and always free. Its phone number is 800-688-7859. Remember that Illinois has a very vibrant assistance program too. For stress, reach out to people. A problem shared is a problem halved. A problem shared is a problem halved. Sometimes you think you get in your little tunnel. You think you're the only one in the world having this stuff happen to you. You're not. You're like everybody else. Addiction is a disease of terminal uniqueness. If you don't stop thinking you're unique, it'll be terminal. Share your problems. Stop doing this stuff. Sometimes addicts and people that are in these throes think they're keeping it secret from everybody. That's not true. Everybody knows way before you that you need help, you need problems. Everybody knows that. So get out of your little world, go talk to people, go share things. There's a lot of support groups. There's AA, there's other things. There's MOLAP. They're great people at MOLAP. Call and share your problem. They'll give you resources. Don't ignore it. Don't be 1980s lawyer, 1990s lawyer where you're going to hide your stress, hide your mental problems, hide all your stuff. Hopefully no one will notice. Why go through life being unhappy like that? Be happy. Share it. Rule 16.01 is, I think, the best written ethics rule there is. Substance abuse causes or contributes to incompetence and malpractice by lawyers. Listen to this. Substance abusers neglect clients, violate rules of professional and judicial conduct, and commit crimes. There can be no more direct way to say it than that. Guard yourself and your family and your loved ones with that. And then should you turn in your friend who's got a problem, turn them in a nice way. There's the intervention committee of the Supreme Court, of which I happen to be a member. Get help for your friend. Get help for the judge. Get help for people. If you're seeing these problems, everybody is in their life isn't happy. Your call, whether it's for suicide, addiction, mental health, your call can save people's lives. Are you going to have to see that person down the road? Yeah. Are they going to come up and hug you and kiss you and tell you that you saved their life? Maybe. I mean, you know what? Life's too short to go around like that. And so be willing to reach out for your own help and be willing to reach out for the friends and your loved ones and other lawyers. And I show you about the barriers to help seeking, the stigma. I can handle it myself, that kind of stuff. Everybody, hey, listen, that's all I got. I'm going to stop sharing this. Thanks, everybody, for listening to our CLE. I hope everybody got a bunch of good takeaways. You can always email Gary@burgerlaw.com if you got something to ask or need a form or want a pleading or anything like that. We always help people. And we really appreciate I know a lot of people have been doing these CLEs for a long time. I really hope you enjoyed them. And I really hope everybody got a lot out of them. I hate meetings that go over, and I've gone over about 5 minutes. So I'm about to end this Zoom. Thanks, everybody. That's all I got. Be well. Thanks.